all. I hope that by this point you've skimmed over the Chin ruling on the Google Book settlement, at least enough to grasp the settlement background and the agreed upon provisions. I want to talk in depth about Chin's objections to the settlement, that is, the reasons he concludes that it's not fair, adequate, and reasonable. There are lots of really cool and important things about the Google Book settlement. First, it would make a whole bunch of orphaned works available again. And it would make it easier for people to find and access books that aren't orphaned. These are pretty important objectives, and the settlement made Google, the Authors Guild, and the Association of American Publishers allies for the first time, rather than enemies. Of course, there were lots and lots of people who were unhappy with the settlement, but that doesn't mean that there wasn't a big group of people who thought it was pretty good. Let's talk about why he thinks that the settlement fails. First, Chin seems sympathetic to objections about the adequacy of class representation. In a class action lawsuit, a large group of people collectively bring a claim to court. This happens when plaintiffs bring a lawsuit on behalf of a large group of people. So, for example, a group of people might bring a lawsuit against a pharmaceutical company on behalf of everyone who took a particular drug. Sometimes the defendants are also a class, but others not. And in this particular case, basically, a big group of people, the Authors Guild and others, are bringing a claim against Google on behalf of everyone whose works were affected by the Google Books project. Chin agrees with some members of the named class, that is, those who aren't the plaintiffs but on whose behalf the plaintiffs are arguing, who've complained that their own interests actually diverge with the plaintiffs and others such that they aren't getting good representation. These folk are basically pointing out that while they have been identified as members of the class in question, their own interests diverge from others such that those interests aren't being well represented, and that seems unfair to them. Secondly, Chin seems to think that the settlement exceeds what the parties in the courts can reasonably determine. It basically establishes a future business arrangement that goes beyond the initial complaint, which had to do with Google's scanning and use of portions of books or snippets. In doing so, Chin claims that it way oversteps what the class action suit and the courts more generally can establish. And this objection has several parts, but the basic idea is that this is something that we need to create or amend legislation for, rather than interpret in light of existing legislation and precedent. Since the courts can only apply and interpret existing legislation, Chin basically rejects the settlement here on the grounds that it exceeds what the courts can legitimately do. So, what does the settlement do that's beyond that? Well, it creates a registry of works and a pile of money that would supposedly be distributed to the owners of those works as they're accessed and otherwise used by Google. But that would happen not because those owners signed up, but because they didn't opt out. So, suppose I'm an author of a book that Google scanned. I may not be aware that Google scanned my book. The settlement would create a registry with a line for my book, and hopefully, if they can find me, my name and my contact information. And Google would give me money when my work was accessed, purchased, or otherwise used. But supposing that they can't find me, and my work is what is known as orphaned, that money just goes into a general fund either to help locate other MIA authors like me, or to fund literary charities. All this happens unless I opt out of the system. Chen points out, and at the very least in theory I think he's right, that questions about who should be entrusted with the guardianship over orphan books and under the terms and what safeguards are probably matters that are more appropriately decided by Congress. Additionally, this whole case was about Google scanning books and using snippets in their search engine. But the settlement gives Google the right to sell full access to entire copyrighted works that it otherwise wouldn't have had. Basically, it grants Google a monopoly over millions of works. And it does this even in light of the fact that Google was kind of a jerk about it. Other competitors were trying to do similar things with the digital book market, but they had to go about the hassle of finding people and getting their permission. Instead, Google was all, whatever, sue us. And they were leveraging their extraordinary capital in order to get what they wanted, basically ignoring the fact that people had copyrights in those works. The result is that not only in the agreement do they have the right to sell full access to millions of books, but that when those works are orphaned, they'd basically have a monopoly over them. This raises all sorts of antitrust worries, and Google's competitors, Amazon and Microsoft, were pretty legitimately upset about it. Also, in most class action suits, there are a lot of folk who never hear about it or who just don't care. This class action suit wouldn't really be any different, and Chin rejects claims that there wasn't adequate notice, that is, that people hadn't done enough to inform someone that their interests were at stake. But he is concerned about a difference between this case and other class action lawsuits. So suppose I took a drug that made me sick. There's a class action lawsuit about it, the case gets settled, and everyone who got sick is entitled to $100. If I don't come forward in a certain amount of time, I waive my claim to the $100. But in the GoogleBooks case, folk who don't come forward are basically deemed to have given up a particular kind of property right. Copyright holders are given the exclusive right to determine who and how their works are used, with the important exception of fair use provisions. But under the settlement, copyright holders are deemed to have given somebody else a license to use their works simply by their silence. Some people think that this just isn't how we do or should think about rights, and that the settlement is missing something important. Another objection to the settlement is that it allows Google to retain all sorts of information about what people read, without including any limitations about how that information can be used. Google says that they're committed to protecting privacy, but there aren't any required limitations on the use of the data in the settlement agreement. And finally, whether they're now well-founded or not, many foreign authors and publishers have raised their own objections to the settlement. Since they are part of the class, their objections count as well. Judge Chin leaves open the possibility that the settlement could be revised in ways that would make it acceptable. And he even makes a suggestion about how to do that. Just make everything opt-in rather than opt-out. That is, rather than having inclusion in GoogleBooks to be the default, authors and publishers should have to opt in to participate. This doesn't fix all the problems, but it would fix most of them, and the others could be addressed in a more specific way, so they could just add a section about privacy and the data collected, for instance. I'm going to be posting a few threads in the discussion forum about the settlement in order to get us started on this topic, but I want to know, what do you guys think about Chin's reasons to reject the settlement? And in particular, what do you guys think about changing the settlement to an opt-in agreement? Can you think of any reasons that this would be a bad thing? And one of Chin's primary objections is that this is a matter for Congress, not the courts. So presumably one big difference is that Congress is supposed to take the interest of the common good into account rather than the particular interests of the identified groups of people. What do you guys think would be different about the agreement if the common good were explicitly taken into account? Aside from Google probably not making a bunch of money, would there be much that was very different? And finally, critics have argued that it's important that rather than waiving a claim to damages, those who don't come forward basically are deemed to have given up a certain kind of property right. They argue that rights just don't work that way. But here's a question. Suppose I leave my car at the public park for a period of time. Won't my car ultimately be impounded unless I claim it? And why is that okay, but not the GoogleBooks settlement?